Who should you pick as your successor trustee in your estate plan? Today, we're going to talk about one of the most important decisions that you need to make when you do your revocable living trust-centered estate plan. And that is who should be your successor trustee. If you're married couples usually make each other as the joint trustees to start off the trust, right? And then when one of them passes or becomes incapacitated, then the other one takes over from there. The question that we're talking about today is who becomes a successor trustee if both of you are incapacitated or if one of you has passed away and the other one is no longer able to manage their estate. So a successor trustee comes in two situations, which is why I like revocable living trust-centered estate plans. Because the first situation that you use a successor trustee is if you are incapacitated. That means you are no longer able to make decisions, financial decisions on your own. And so your successor trustee steps in your shoes as the trustee of your revocable trust and takes over your assets. Makes certain that bills are paid, that your electricity is paid, your water bill is paid, your insurance is paid, and basically just takes care of all of your assets. Now, why this is so important is because if you don't have that in place, then somebody, probably one of your relatives, is going to have to go to court and get a guardianship or a conservatorship over you. And that's expensive. If you can make that decision ahead of times, then there is usually not any court intervention at all. The successor trustee usually just takes over by initiating the correct documents like a certificate of trust or affidavit of trust showing that they are now the currently serving successor trustee of your estate, even though you're still alive. Then the second thing is probably what most people think about and that's after you pass away. So after you pass away, there has to be somebody to administer your estate, and that could mean distributing your assets and closing everything down. Or maybe if you have minor children, that means that they will essentially be the trustee of your children's trusts until certain mile markers are completed. Like maybe when they're 21, they get a little bit of money. When they're 30, they get a little bit of money. And when they're 35, they get everything. It's your decision, remember? Because in all of our other videos, we talk about that a revocable living trust-centered estate plan is customized to exactly what you want to happen. It's very important whoever you pick as your successor trustee agrees to take that fiduciary role on. In other words, they agree to do everything that you want to happen in that trust document and to carry out your wishes exactly the way they are. And just like I talked about having a successor trustee when you're incapacitated, your successor trustee, when you pass away, will help your estate avoid probate. And depending on what state you are in, guys, probates are running anywhere from about $3,500 to about $7,000 on average right now. And that is if everything goes perfectly. If they don't, they're gonna get expensive really, really quickly. We have had probates in the last couple of years, and I've talked about them in other videos, that have cost $18,000. Another one cost almost $23,000. And another one was just over $34,000 for a probate because the heirs were fighting. So it's very important for you to pick somebody as your successor trustee for incapacity and for death, that person you trust explicitly. And I always tell couples, especially couples with children, that you don't have to make all of your children have a role in your estate. As a parent, you know better than anybody what the personalities are of your children. And if you have a child who's not good with money, then don't make them a successor trustee. That's not the role that they should be in. They're gonna get frustrated, they're gonna fight with everybody, and they're gonna make your estate plan become a disaster. Pick somebody who you trust implicitly. And it might not be your adult children. It might be a friend. It might be a lawyer, your CPA. It might even be a professional trust company. The bottom line is you have to pick somebody that you trust implicitly, that you know is going to do exactly what you want to do because they have told you and you have talked to them and they're going to follow your directions to the T in distributing your assets and taking care of your loved ones, whether you're incapacitated or you've passed away. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.